Supreme Court's coming back in. Go ahead and touch me up at your leave. Thank you, sir.
Mr. Williams, I think your time expired.
If I could just have one more minute, Your Honor.
I just hope everybody had their sunscreen on. So sorry about the interruption.
That's quite all right.
Continue on.
I was afraid the microphone wasn't working because I heard buzzing there. I was discussing the 3523G provision and the question as to that the petitioner has raised, that it's the whole election process that is impacted by this. And the reason that that's not the case is because when you're trying to determine whether a statute is retroactive, you're looking at the event that is being regulated and when that occurs in relation to the passage of the statute. Now, in Martinez, in Justice Walker's opinion, there was a question about the application of that statute, the change in the punitive damages. Ultimately, that decision did not rise and fall on the question of retroactivity, but on the determination that a substantive right was not at play in that claim. But the opinion did go through the process of describing how we traditionally deal with retroactivity. And what is important to note for the facts that we have in this case is that, notwithstanding the fact that Mr. Blankenship ran as a Republican, lost in the primary, changed parties, was designated, as we stated, the nominee before he changed parties, and then started the process of collecting signatures, until the point that he presents enough signatures to actually place himself on the ballot, the whole issue and the whole question of whether or not the sore loser provision even applies is really just speculation. Up to that point, the defining point, the actual defining event that is being regulated by the sore loser provision is his attempt to get on the ballot under the nomination certificate process. And under those circumstances, all that happens subsequent to the passage, the enactment and passage of the bill. Under those circumstances, then there is no retroactivity. Now, the petitioner concedes that the statute as drafted is within the state's authority. Petitioner concedes that the statute as drafted precludes his ability to be on the ballot. The only question then is, in addition to these constitutional issues, is whether or not it applies retroactively. Because we have a long line of jurisprudence in this state and others that hold that you're looking at the event that you're attempting to regulate, and that event which is being regulated is the point at which he applies to be on the ballot with the signatures for the Constitution Party, that will define whether or not retroactivity applies. So under those circumstances, it is not retroactive. Now, he provided to the court, and it was pointed out, the Poindexter case and another case out of North Carolina, Poindexter in particular, that was decided just last week. But as the petitioner acknowledged, those facts are very different than what we have here. And in fact, I believe you can read Poindexter to be consistent with the position that I'm advocating for how you should apply retroactivity. Simply for this reason. In Poindexter, they had been sought to get on the ballot, had been approved and designated to be on the ballot. The legislature then subsequently passed the law, and then the Board of Elections in North Carolina determined that that was a violation of the statute and had to be taken off. So if we look at, again, the event that's being controlled, that happened after they were approved and actually were on the ballot, not the facts we have here. So for instance, I think that you could very easily say that Poindexter is consistent with our decision in Martinez and the position that the Secretary is advocating in this action. As an example, let's say that the legislature had passed the provision of 3523G, and because of some delays in either special sessions or whatever, it didn't go into effect until August 15th. If Mr. Blankenship had actually submitted his petition in July, but the law did not go into effect until mid-August, then it would be a retroactive application. And in fact, the Secretary's position would have been different at that point, that under those circumstances, the law would not apply to that, and he would have been allowed to be on the ballot. But in this case, it went into effect in June. He submitted his materials in July, and under those circumstances, it's not retroactive.
How about the constitutional argument? Professor Baxter says under 23.5, or paragraph A, that there are constitutional issues there.
There are two constitutional issues that are routinely drawn, well, actually three. One would be a due process claim, and there's really not a legitimate due process claim for the reasons I've expressed, that if there was a retroactivity provision problem, then there would be a due process claim, as there was in Judge Chambers' opinion and as there was in the North Carolina case. For the more standard constitutional claims that are asserted, which involve associational rights and equal protection, it is a balancing test. And what this court has to determine is look at the infringement on the right that is being imposed by whatever the state is attempting to do, and the right that the individual has to be on the ballot. And the more restrictive and overbearing the restriction is from the state, then you get into heightened scrutiny. What we have argued, and what the Republican Party has argued, is that this is a limited restriction. And under those circumstances, the balancing is, does the state have a legitimate interest that should carry the day? And frankly, all the courts that have looked at similar statutes have made that holding. The fact that we have a very narrowly tailored provision that doesn't deny him access. He does have the right, as we discussed, to seek through other processes to be on the ballot through a write-in candidacy. The fact that the Constitution Party, as a petitioner, had the right to put other individuals on the ballot and are only limited by the small number of individuals who had sought the same office in the primary in the same year. That's about 6 or 7 people at most. Under those circumstances, and considering what has been designated, understood by both the U.S. Supreme Court and other courts as the compelling interest that a state has in actually in implementing a sore loser statute, then those constitutional challenges fail, as they have in every other time they have been raised in this kind of case. It's important to note, in the Poindexter case that the petitioner provided to you, there's a provision in there where that district judge notes that neither side actually contests the fact that North Carolina has a compelling right and a compelling interest in preventing sore losers from running. The only question there was whether there was a due process provision.
How about the argument that he made that the title to the amendment doesn't pass constitutional muster?
Well, the whole question of notice, or the whole question of the title, goes to the issue of notice. As was noted by several of the questions from the bench when the petitioner was here, it is hard to argue that Mr. Blankenship was not on notice of the fact that there was a change. The reality is that the description of the change in the law did reference 3.523, and so it draws the attention of the reader to that statute for that purpose. None of our cases have required that the title list every single change. That's not consistent with our jurisprudence. And frankly, considering the fact that the title itself made reference to the fact that 3.523 was being amended, the fact that he had been provided with the Secretary of State's own version of his interpretation of the election law statutes through the handbook that said that a sore loser provision exists, it's hard to argue that subsection A is somehow invalid. Keep in mind that even if you were to find that the title to subsection A was inappropriate, there's no question that subsection G applies. And under those circumstances, that would bar him. So I don't want to belabor this, and there's much more, there's a lot more detail on a lot of these issues that are addressed in the brief. But I know that others want to discuss these issues as well, but if you have any other questions, I'd be happy to answer them. But otherwise, I would just say that the Secretary of State requests that the petition be denied.
Thank you very much. And now we'll hear from the intervener, the Republican Party. And welcome back to West Virginia, Mr. Lim. We don't do all this hoopla for everybody, so.
Thank you, Your Honor. I'm very happy to be here. I was telling Mr. Williams that he missed a chance to make a joke about the hot bench. So good morning.
And that's literally true around here.
Good afternoon, I guess, at this point, Madam Chief Justice, and may it please the Court. My name is Albert Lynn, now from the law firm of Hutton Andrews Kurth, and I represent the intervener of the West Virginia Republican Party. I will endeavor not to repeat, because I think Mr. Williams has covered many of the points very well. There are just a few things that I want to highlight, and I do want to start by stressing the point that Mr. Williams made at the end, which is only one of these statutes needs to apply here. We think, and we agree with the Secretary of State, that both A and G bar the second candidacy of Mr. Blankenship. However, this Court only needs to conclude that one of them applies and find it constitutional under the Anderson verdict test. If I could, I'll turn to A first, because there's a point that Justice Motes made earlier that I think is important to point out. There is only one reasonable reading of 3523A, and that is the reading that Justice Davis reached in her dissent in Wells, and I think that that is very important. That I don't think, while it was not necessarily squarely presented in that case, the fact that Justice Davis had no problem reaching that conclusion in sort of an offhand statement, I think confirms that there's only one reasonable reading. And the reason for that is this. Imagine yourself as an individual in the Secretary of State's office who is receiving a nomination certificate filing around August 1st. That individual has to apply the statute. And the question that individual asks him or herself is this individual seeking a nomination certificate candidacy, quote, already a candidate in the primary election? And the answer to that in the case of Mr. Blankenship is unequivocally yes. He is, quote, already a candidate in the primary election. There's no ambiguity there. There is only one way to read that statute, and it applies to both Blankenship, but it also applies to Mr. Jenkins, Congressman Jenkins. It also applies to Patrick Morrissey. It also applies to Joe Manchin. It is both a cross-filing prohibition and a sore loser prohibition. Professor Bastress has made much of the fact that it doesn't reference losers. What it also doesn't reference winners. What it talks about is anyone who competed in the primary election cannot take advantage of 3523. The petitioners have somewhat changed their position here today. In their briefs, they appear to be arguing that it is only a cross-filing prohibition that applies only to Attorney General Morrissey or Senator Manchin because they won. But he seems also now to be suggesting, the petitioners are, that the statute, because of the present tense R, should be read only to apply during the pendency of the primary election. In other words, from January until the second Tuesday in May, right? And then after the second Tuesday in May, the prohibition no longer applies. Well, I think as was suggested earlier by the court, that doesn't make any sense because that would make the statute entirely useless. And this court has said repeatedly that it is not a reasonable reading of a statute to read it in such a way that would make it useless. And the reason it would make it useless is anyone who is covered by that prohibition would simply wait until after the second Tuesday in May and then file. So there is only one reasonable reading of A, and we think A clearly applies. As to the title argument, as we have discussed in our briefs, there is no principle in this court's cases that requires, when the legislature chooses to be specific, that it must be really, really specific. And for good reason, because imagine how unadministrable such a rule would be. What incentives would this court be giving the legislature? That if you chose to, you could be vague and just identify the section, but then if you chose to be specific, you have to identify all of the changes in the amendment. The incentive to the legislature would then be just always to have vague titles. The principle that is in the cases is that the titles cannot be actively misleading. And if you, Your Honors, if you read those cases, you will see they talk about titles that discuss certain things and point the reader away from the statute. So in the Copley Garage case, talked about the regulation of electric utilities, but didn't mention the deregulation of wreckers. In the Walton case, it talked about the regulation of osteopathy, but didn't talk about medical doctors. So that's what we're talking about in those cases. There is no such problem here. On G, as to retroactivity, again, I think Mr. Williams covered it very well. I did want to point out this fact. Professor Bastrus, in his brief, never once discusses the standard that Mr. Williams was talking about, which is the test for retroactivity. And that test is articulated in Sizemore and Public Citizen and Martinez, and that test is, when was the regulated conduct completed? And Mr. Williams, I think, has covered that very well. I'm actually glad that Professor Bastrus has brought up the Poindexter case and the Anglin case, because I think, as Justice Motes has noted, those cases give this court a very nice contrast of what is a retroactive application and what is not. And in those cases, it was so clearly retroactive, because again, as Justice Motes has said, those individuals had completed the filing process, they had been submitted their fees, had been accepted onto the ballot, had been certified by the state election board, then the law was passed by the legislature, and then that certification was revoked. That is clearly retroactive because the events that are regulated were completed before the law went into effect. And it was so clearly so that the state of North Carolina in those cases, if you look at footnote 7, did not contest retroactivity. The facts here are very different. And Professor Bastrus has conceded, and he says, quote, the timing was somewhat different. Well, he says that as if it doesn't make a difference, but in the analysis of retroactivity, timing is everything, right? So if the timing is somewhat different, that's going to affect, the ultimate conclusion that this court reaches. The last thing I wanted to talk about is the constitutionality. And again, I thought Mr. Williams' presentation covered it very well. The point that I did want to stress is this. The Anderson-Burdick test dictates whether or not strict scrutiny or rational basis applies. And all of the objections that are being raised by petitioner, they have their hypothetical of 11 situations where certain different things might happen, and they're objecting to the tailoring of the statute. Professor Bastrus doesn't say it because he knows this is a problem, but he's trying to smuggle strict scrutiny in through the back door. To do the test, you ask yourself 3 questions. Is there a severe burden? Is the statute discriminatory? If it is neither of those 2 things, then it is simply rational basis review. And both briefs on this side of the V have articulated a number of legitimate state interests here, including, if you look at the Supreme Court's cases in Klingman and Burdick, a specific interest in preventing sore loser candidacies. And so really the only question is there a severe burden and is it discriminatory? And for all the reasons that we've discussed, it is not. And so I would just urge this court to, when you do the analysis, Professor Bastrus has thrown a lot of terms out there about narrow tailoring and compelling interest, but all of that is strict scrutiny. Strict scrutiny does not apply here unless you have first concluded that there is a severe burden and that the statute is discriminatory. And the only argument they have that the statute is discriminatory is that it treats recognized minor parties differently than unrecognized minor parties. In other words, the Libertarian and the Mountain Party differently for those who are unrecognized. And as we walk through in our brief, the Supreme Court of the United States has held time and again in Jenness, in Storer, in Timmons, that the mere differential treatment of recognized and unrecognized parties is not discrimination under the law. And as the court said in Jenness, sometimes the grossest discrimination lies in treating differently situated entities as if they are alike. So for those reasons, Your Honor, we would ask that the writ be denied. Thank you.
Thank you. Professor Bastrus.
Were you going to argue? I'm sorry, Chief, but there is one other intervener.
Oh, I'm
as a
sorry.
respondent.
I'm very sorry. I did not mean to pass you over. Go right ahead.
May it please the court, my name is Nigel Jeffries. I'm here on behalf of myself as an intervener. I think there is something to be made about the cases cited by respondents and how they're distinguished here. The Supreme Court multiple times has upheld sore loser laws, and my remarks are going to be confined to the constitutionality for purposes of associational rights under the federal and state constitution. Every case that they've cited took place in an open primary.
In what?
In an open primary system. In those cases, all the horses are lined up at the gate at the same time. They go in front of technically the entire electorate. So when you don't win, if you do not get 1% of the votes, you're weeded out, which makes sense. You shouldn't get a chance to go back up in front of the entire electorate. All we're talking about is a very small slice in West Virginia because we hold semi-closed primaries. We do not allow Democrats to vote in Republican. We don't allow Republicans to vote in Democratic primaries. That's not the case in about 25 different states. Every state cited, every case cited here, Burdick, open primary, Garza, open primary, Monroe Socialist Workers Party, primary, because here's the difference. All those individuals had a reasonable alternative to channel their associational rights in the primary. We don't have that here. So, for example, if the Constitutional Party in many states would have had to have either chosen the nominee or to hold back because they chose their nominee at the same time the Republicans did. So the Constitutional Party could have said, I'm stepping back. I think that we ought to endorse Mr. Blankenship in the Republican primary. Let's put all of our efforts into that race. Here they don't have that. It's two-tiered. They don't select until after the primary. So it's somewhat unreasonable to ask them to make that decision up front when they have this secondary, hey, you didn't win, why don't you come be our nominee? All you have to do is disassociate. And that's what the Wells case is. It's a disassociation law, and so is Storr. Storr is not a sore loser law, but disassociational cases, those actually work. And I think that if you had that here, it probably would be constitutional. Sore loser laws and closed primaries and semi-closed primaries don't make any sense. You're not actually preventing the number of candidates from appearing on a ballot. You're not decreasing that amount because, like I said, Mr. Blankenship can still be a write-in. He can still be a candidate on Libertarian or Mountain Party. You're not doing anything to prevent voter confusion because he's only on the ballot, Mr. Blankenship, is only on the ballot in about 35, maybe 40% of the actual ballots that are printed. And so when a formerly Democratic voter goes into in the general election, they've never seen Don Blankenship's name. That's not true in a lot of open primary states. In a lot of these states, you actually get both ballots and you check them over, and then sometimes you just discard the one that you don't use. Or you have to go in there and affirmatively say, I want to get the Democratic ballot or I want to get the Republican Party ballot. And you make that decision at that time. So I think there is a distinguishing marker here that makes this somewhat a case of first impression, because they have upheld sore loser laws in all these states, but they've not been challenged in semi-closed or closed primary states. West Virginia is a semi-closed primary state. So this court would have to do a different analysis. And I think here the burden is severe. You are saying that a very small select of preference of the Republican Party is now dictating the associational rights of not only the Constitutional Party, but everybody else who didn't vote in the Republican Party primary from ever seeing that candidate. I think that's a problem. And furthermore, it doesn't actually further the interests of the state. Again, frivolous candidacies, those are usually ferreted out by the petition requirements that we require anyway. So why have this extra requirement? Again, in open primaries, a lot of those frivolous candidates are taken care of because if you don't get 1% at the primary, then you're weeded out. There's not a separate, well, you have petition to get on the general election ballot. You went in front of the entire electorate. If you couldn't get 1% of the entire electorate's vote at that point, then you shouldn't get a second opportunity. Here it's not the case, and it's different, and this court, I think, needs to recognize that. I think it got somewhat glossed over on both sides here, but this is a distinguishable case insofar as the primary is set up differently here. I think that they could have drafted the law as a disassociation, saying, hey, you can't change parties 100 days before an election, and that probably would have taken care of it. That's what happened in Storr, and they upheld that. But it's not a sore loser law. This was crafted to keep off one person, one idea from the ballot, and I don't think it furthers the state's interest in this action, and the burden on people like me, voters. Association rights are very severe, and I think under that Anderson verdict test, because Burdick said the same thing. Voters, the reason why they prohibited write-in candidates at that point was they stated voters had an ample opportunity in which to channel their expressive activity in the primary, because it's an open primary. We don't have that here. Voters do not have a reasonable alternative in which to channel their expressive activity in the primary stage because we hold a semi-closed primary. And I think for that very reason, I hope the court would view this under the Anderson-Burdick test, but would find that it is a severe burden on associational rights, and it does nothing to further the actual interest of the state, or their purported proffered interest of the state. And for that reason, I would ask, unless the court has further questions, that the writ be granted.
Thank you very much.
I have just a few quick points. As I wrote down what Mr. Williams was saying, provides a trigger for application of the retroactivity doctrine. I may be paraphrasing him, but I think this is the essence of it, that one of the triggers can be ask whether the statute acts upon pre-existing rights. And that's precisely what happened in this case. When Mr. Blankenship filed to run for the Republican primary, he had then, under the pre-existing law, a right to run after the primary, regardless of whether he won or lost, for to be nominated by one of the other parties. And that was cut off by 3523G. So he lost the pre-existing right that he had. And the fact that there are other cases that are perhaps also examples of retroactive applications does not diminish the fact that this one was as well. Mr. Williams also said in his arguments with regards to the validity of the title, he sort of slid back and forth between Section 23A and 23G. The fact that Mr. Blankenship had the election guide or perhaps some foreknowledge of the fact that Section G might be enacted does not affect the validity of the title in subsection A. There is no evidence in the record of what the election guy said before 2012, so we don't know if that was providing prior notice in 2009 or not. Mr. Lynn characterizes our interpretation of subsection A, that it would create a useless statute, which I hardly disagree with. In 2009, the legislature made the judgment that persons seeking primary office should not be simultaneously seeking access to the ballot through other means, most notably Section 23, petitioning process. And it's also a legislative judgment that after the primary, the candidate is in fact free to pursue the petitioning process on the theory that candidates should have the right to be nominated by more than one party if they so choose, or if they have lost in the primary, to seek nomination elsewhere. That's a legislative judgment, and it's reflected in subsection A. And it's not a useless one. It's simply a different legislative judgment. Subsection G, of course, takes away the post-primary abilities of persons who lost in the primary. And as to the debate on strict scrutiny versus rational basis, I think my argument was it doesn't matter what you apply, because there's no rational basis to justify excluding minor political parties from running sore losers while allowing the other parties to run them. So there certainly are rational reasons for treating major parties and minor parties that have had some electoral success differently in some context, but this is not one of them. It as much sense as it makes with regards to creating means of access to the ballot, it simply has no bearing on whether a party should be able to put forward a primary loser. And unless there are questions, I'll sit down and let you folks.
We're done. Thanks, guys.